Hello, this is attorney Gary Finklea from the Finklea Law Firm in Florence, South Carolina. Today I wish to speak with you regarding an allonge, A-L-L-O-N-G-E. I must admit that I was not fully aware of the significance of those documents until late last night when I was burning the midnight oil trying to prepare a defense from a client who had very little hope or help in a foreclosure matter scheduled for today. Fortunately, I was able to do some research, and based upon that, I was able to provide the client with just an absolute great defense to this foreclosure matter. Fortunately, I didn't have to use it because some other developments, but I've got this ace in a hole now for almost any sort of collection on a debt that has been transferred from original creditor. Let me give you some background on what an allonge is and how it affects litigation that I'm often involved in. First, an allonge is typically a piece of paper annexed to a negotiable instrument or promissory note, typically, on which to write endorsements for which there is no room on the instrument itself. Such instrument must be firmly attached to the instrument to become part thereof. So that doesn't help us very much, but basically a allonge is a document evidencing a transfer or assignment of a promissory note. For example, it happens all the time with home mortgages. You know, you may get your home mortgage from a local financial institution, and then later it's assigned to GMAC or to Ocwen or to Chase or some other provider, or credit card accounts, for example. The original credit card account may have been with Discover. Discover assigned that account to some third party when you went into default to attempt to collect it. Those subsequent parties will often sue the borrower in an attempt to collect the debt. Well, in connection with any foreclosure or any debt collection matter, the lender must of course prove that they are, or the plaintiff must prove that they are the holder in due course. In other words, they have the legal right to take action on that note. We're not going to take their word on it. So, we're going to require them to produce some assignment document evidencing that proof of ownership. Generally, the way that they do it is through some assignment or through an allonge, which is a separate document evidencing that assignment. Well, based upon some law that very few lawyers are aware of, and specifically the state code and the Uniform Commercial Code, section in South Carolina is 36-3-202, which in the Uniform Commercial Code it would be section 3-202. Uniform Commercial Code is generally uniform throughout all the states in the United States that adopted this code. But the code specifically provides an endorsement must be written by or on behalf of the holder and on the instrument or on a paper so firmly affixed thereto as to become a part thereof. On a reporter's comments to that, it states that this section follows decisions holding that the purported endorsement on a mortgage or other separate paper pinned or clipped to an instrument is not sufficient for negotiation. The endorsement must be on the instrument itself or on a paper intended for the purpose which it is so firmly attached or fixed to the instrument as to become an extension or part of it. Such paper is called an allonge. So the rule is, first, if you can, the endorsement or assignment needs to be made on the note itself. If there is not room on the note itself, and there is a multitude of cases explaining the, quote, no case rule, end quote. For example, there's just no room because of all the other words and language on the promissory note. You don't have room for it. Or alternatively, if it's not on a document, then it has to be affixed. The allonge has to be affixed to the note to become a part thereof. Some cases hold a paperclip is not sufficient for it to become part of the document. In this morning's case, I never had to pull my ace out of the hole, but the allonge was a completely separate document. The note, though an original of the note was produced, was not attached to the Allonge, and therefore I think my argument would have held water. So, the moral of the story, or who this will benefit. First, if you are a consumer out there and you're in litigation with a debt collector, let your lawyer know about this issue, because I guarantee you not many of them know it. I've never heard this argument made. Second, if you're a lender or a foreclosure attorney, you better get your documents straight, because if I come across you, I'm going to argue that you are not a holder in due course and do not have the authority to enforce this document. But, you know, in all honesty, for the bankers and the foreclosure lawyers, you know, you need to take a look at this. I actually communicated this with 2 lawyers in my office today that do foreclosure work and who do assignments, and they were surprised to learn of the rules. So I hope I've answered, well, not answered because I guess you didn't have the question to begin with, but I hope that I've explained what an Allonge is, and I have really enjoyed learning about this, and I love when I find some unique legal argument like this that I can use in a case. I just cannot wait to pull this rabbit out of the hat, because I know that the defense lawyer will not be expecting it. So, you know, if this firm can help you with any legal matter, whether it be a debt, an accident, an employment matter, a disability matter, domestic issues, please feel free to give us a call. We can be reached at 843-317-4900, or you can reach us through the website at finkleylaw.com. My email address is gfinkley@finkleylaw.com. Thank you very much and have a good day.